One of the questions put to me was that one of the students is from Hong Kong, and which is a common law jurisdiction, and wanted to know how civil law jurisdictions would impact the application of international tax in, let's say, Hong Kong, which has a common law jurisdiction based on Old English common law system. Now, one of the books is the Comparative Tax Law by Victor Thuroni, and it contains a number of very interesting chapters just on how tax law is developed and how it is developed, I guess, in the different legal jurisdictions. And the section that comes to mind in answering that particular question is chapter 4.6, which is at page 121 of the textbook. And if you've got a PDF copy, which I think all of you have, you'd go to page 145 under the heading Administrative Law. And I'm going to just read an extract from this, which really answers that question quite nicely. In civil law countries, tax law may be considered a branch of administrative law. Whatever one feels about this classification, it is clear that in both common and civil law countries, general principles of administrative law apply to tax. These principles govern such matters as agency power to issue regulations, requirements of procedural due process, and judicial review of agency action. Even in civil law countries, these principles may derive from judge-made law as much as from statute. The power to issue regulations in common law countries is generally found as a matter of delegation from the particular statute. In civil law countries, there tends to be a general constitutional power in the executive to issue regulations, although the details will differ depending on the constitution. Thus, in France, the Constitution gives an autonomous power to the executive to issue decrees in areas that do not fall within the domain of the law, although for practical purposes, administrative regulations to implement the law are of greater importance. Laws may also delegate to the executive authority the authority to regulate specific matters. Although it may be as much a matter of practice as of law, the relationship between statute and regulations is a key element of tax law. One might have different views about the best mix of statute and regulations in terms of where the details should lie and how much they should be elaborated, but as a matter of practice, countries differ substantially on this point. And so he goes on to examples. The key point that emerges here in addressing why it would be important to understand the common law background legal system versus the civil background legal system, albeit that you may be in Hong Kong, the reason why you're doing an international tax course or would be studying in the field of transfer pricing is that you're either with an advisory firm that has clients in many different jurisdictions, and those clients themselves will be multinationals that operate not just in, let's say, Hong Kong, but will operate in Hong Kong, in France, in Ghana, in South Africa, and a variety of many other different countries where the relationship between those associated or connected persons exists, and each of those legal entities that exist that are associated with each other are subject to different legal systems. And that is going to prescribe particularly when it comes to regulatory issues where most of you are involved, and that is the completion of compliance matters such as the filing of tax returns, withholding of withholding taxes, paying value-added tax, paying sales tax, whatever the case may be. The tax systems in each of those countries are to a large extent driven by empowering statutory provisions, and particularly in civil countries, the detail goes into the regulations that would be issued, although that also happens in the common law jurisdictions. And that is where you are able to test the extent to which the revenue authority in each of those countries is acting within the scope of their power. So a revenue authority cannot just do what it wants to do. It must comply strictly with any of the empowering laws, be they in the form of a statute, be they in the form of a regulation, or it might be the adherence to a particular trite principle of law that has been developed in the court system and made a particular way of conduct trite in law. In other words, it's entrenched in terms of what the common law principle is. And to the extent that that revenue authority acts outside the scope of those powers, it would be acting ultra vires. It would be acting outside its normal powers, and therefore those particular actions by it would be subject to judicial review, which means you would be able to go to the court system and challenge what they have done. And in the many years that I have practiced, much of my litigation, and you may know that my background is that of a tax litigation lawyer, where I act as advocate for multinationals, and I do so in many different tax jurisdictions throughout Africa, and I also have the right of appearance in the United States of America, that oftentimes the challenge that we make on the merits of a particular case is matched with alternate challenges against the fact that the revenue authority has acted outside the scope of their powers and therefore is not entitled to do what they are in fact doing in raising the revised assessment. So it's very important that, albeit that you may not be a qualified lawyer, that you as tax advisor or as a tax director or tax manager within the organization understand these basic principles so that you know how to go about challenging any particular revised assessment, because that's ultimately what we end up in a challenge after any type of tax audit, how to go about defending the position of your client or the multinational. Now, even in the case of the audits, there's a particular process that must be followed. And for the most part, it is relatively similar in most jurisdictions, where the authority, the revenue authority, is given extensive powers to access information from you, the taxpayer, in order to check that there has been proper compliance. But in doing so, it must follow certain steps. Oftentimes, the auditors that are given the duty to conduct the audit must have letters of authority, and those letters of authority specify what they are entitled to do in the audit, which means they cannot act outside the scope of that audit. And more importantly, in the process of collecting that information, they are expected to respond to you and to give you their state of play, what they believe has gone wrong, and explain to you what their next steps are going to be in wanting to issue revised assessments, so that you, the taxpayer, have the opportunity to respond to that well before the actual assessment is raised. Now, oftentimes it happens that there's a knee-jerk reaction because the revenue authorities are chasing a deadline, in that there's a prescription period that's about to expire, and they'll typically then use that as an excuse in raising an immediate assessment and not giving you the opportunity to respond to what I would refer to as the letter of findings. That is unlawful conduct on their part, and that is them exercising a power that falls outside the scope of the powers that they are entitled to exercise and the tramlines that they must follow. And in that particular instance, you are entitled to challenge what they've done. I can give you an example. Some years back, and this was in one of the African states, the taxpayer was facing literally in excess of R1 billion revised assessment. And the audit process had been agreed upon between the taxpayer and the revenue authority as to what exactly was being audited, so that the taxpayer knew what and how to respond. And the Revenue Authority ran out of time and very quickly issued this generic letter of findings so that it could issue the revised assessment, because the time period was going to prescribe literally in the next 3 or 4 days. And we brought an urgent application setting aside the letter of findings as being unlawful and invalid, and won the case. And that meant that the Revenue Authority had to withdraw the letter of findings, and therefore they were not in a position to issue any revised assessments, and that was the end of the matter. So that's a fairly good illustration of why it is important to understand these differences.